Call the fourth case on this morning's docket, case number 108062, State v. Sprague.
May it please the court, I'm Heather Cessna with the Appellate Defender Office on behalf of the defendant, and I would like to request 4 minutes for rebuttal time, please.
4 minutes is granted.
Thank you. I'm going to start this morning sort of at the end of the briefs here, and that is obviously since the original briefs in this case were filed, the hard 50 sentencing issues have kind of settled down a bit. The state filed the 609 letter and this week, which we agree on the state of the law, with the exception that to the extent that this court has backed away in Roeder from addressing the sufficiency of the aggravating factors, I think our argument would still be that the aggravating factors need to be addressed for sufficiency as they have been in the past. So to the extent that that's changed in Roeder, we would disagree with that. If there were no other specific questions
Explain that.
Yeah, I mean, our argument on that is that the language of the statute still contemplates that if for any other reason other than sufficiency of the evidence that...
But there is another reason, and the reason is that it's unconstitutional.
Well, and I guess, Your Honor, our contention is that that potentially implicates, I think, some kind of double jeopardy issue potentially, because the state's already had a bite at the apple and essentially failed to do so. So to give them another opportunity...
Why does that arise until you get back? If they don't attempt to utilize the new statute, then you don't have any problems. But if they do attempt to use the new statute, then you're going to have to go through the whole process again, and they're going to have to present the evidence again. They're not going to do it based on the transcript of the voided statute, are they?
Well, I guess, I mean, part of our argument, I think, is also in the interest of judicial economy, because to the extent that they are going to rely on the same issues, I think...
But would they be required to, since it's a new statute and a new procedure?
I suppose
and a new trier of fact.
I suppose it would be up to them. I guess my assumption, and perhaps this is an erroneous assumption, but I suppose my assumption would be that if they had other aggravating factors that they were intending to use, that they would have presented those to begin with. So I think But
they wouldn't necessarily present them the same. And if you're arguing that the aggravating factor wasn't proved, and they're going to have a new procedure with new evidence and a new trier of fact, how can we rule now that will be insufficient? Well,
and I guess, I mean, I suppose your assumption there is that because it's under a new statute that the potential double jeopardy issues is not applying there. Is that sort of your underlying assumption?
Well, I'm saying if it does apply, then that issue will arise then.
True.
We don't have a double jeopardy issue until they try to do it again.
Until it comes around a second time.
And if you go back and you just stipulate to not applying the aggravating factors and sentencing otherwise, then we don't have a problem. And that would be much more efficient.
I suppose it depends on how you look at efficiency. I would like them to be just told up front that that's not sufficient, but I can see your point. Yeah, I mean, with the exception of that, like I said, I think that we're mostly on the same page as far as what the status of the law is with the rest of the sentencing issues. So to that extent, if there's no other questions about that, we'll move on to the conviction issues in this case. I was going to start off talking about the ineffective assistance of counsel claim. Our concern with the ineffective assistance of counsel claim here is that it appears from the conversation that was had at the district court level between the defendant and the judge that the defendant made potentially important allegations that his attorney basically was failing to investigate potential witnesses or investigate any evidence, and that the judge essentially relied on the idea that this was trial strategy without it having any evidence to support that. assumption. There was no questions asked of the defense counsel regarding this, and our contention is essentially that without asking the trial counsel some questions, that the trial judge's assumptions that it was a trial strategy that caused her not to put on any defense evidence was not supported by substantial competent evidence, and would have required that there was more investigation there.
Can you point in the record to where that issue was raised before the district court, the issue of a failure to investigate?
Well, I think they had an extensive conversation about it, and I can probably grab a specific citation for you when I sit down here, but they had an extensive conversation about it specifically. He filed several motions throughout, but then he also included a conversation at sentencing where he complained about the fact that he had, potentially other evidence and that his attorney had failed to put that information on. So I can.
So your argument is that that issue was raised during the colloquy with the court, not in the motion.
I think he included a variety of concerns in his various motions, and that he also included that when he spoke to the court directly.
Okay, so you think it was included in the motions that he filed?
I'd have to go back and look now that you're asking me that, just to make sure.
Thank you.
But I thought it was originally, but I'll have to go back and look just to make sure. Certainly he, and the court had an extensive conversation with my client about these issues, but never asked the attorney. And that's where our complaint here is that I don't think that the trial judge can then turn around and say, well, this was mostly a trial strategy and she did a very good job, and your complaints don't require any further hearing or concern at this point, because essentially he found they were invalid and he denied the motion on the merits without actually asking any more extensive questions about that from the defense attorney. Moving on to the prosecutorial misconduct issue, the state has conceded in its brief that the use of the word preposterous was inappropriate. We would agree with that. And our argument here is mostly on the motive to come in and tell their version of the story as far as the state's witnesses. Obviously, the state's witnesses had some motive to come in and tell their version of events, even if it's just simply to comply with the subpoena, whether that's a desire to see a conviction in a murder trial about whether a friend was a victim. I mean, they have some motive to come in besides just the pure goodness of their hearts. And so to suggest otherwise, I think, is erroneous. And particularly in a case like this, where so much of the evidence really depended on whose version of events you believed. Obviously, there's no question that there was a dead body here. Obviously, there was a killing of some sort. Mr. Sprague's allegation was that this was in self-defense, essentially. And the question of whether or not they found that it was premeditation versus self-defense or some lesser form of the homicide, I think really depends on how you're going to view the credibility of the witnesses that were involved in the trial. And so to the extent that the state has improperly bolstered the witness credibility, and to the extent that has essentially torn down my client's credibility by the use of the word preposterous, that has affected his right to a fair trial. As far as the multiple acts issue in this case, we'd acknowledge that as the state actually cited to Soto in their 609 letter regarding the hard 50, that is controlling of the multiple acts issue. If there's no further questions, we would submit the rest of the issues on the brief and ask that the court vacate based on the arguments that we've made here and on our briefs this morning.
I wrote a question to myself when
Sure.
I was reading.
On that, I'm sorry.
I made a question to myself when I was reading the material, and then it's been a few days since I looked at it. What I wrote here was the pro se motion for new trial timely as a motion for new trial. Was it inside or outside the deadline?
It was outside the time for a motion for a new trial. And this court has previously addressed motions that allege ineffective assistance of counsel even when they weren't timely. I think some of the distinctions that have been drawn in the past have been whether or not the client, for instance, has a constitutional right to counsel. If it's timely, I think this court's previously said that timing affects it. And certainly the district court, I think, did make a ruling on the merits here, so I think it's appropriate that the court consider this issue as we've raised it here, even though it wasn't filed within the new trial deadline.
That's not jurisdictional, the time limit?
I think when you're talking about pro se, I would argue that it's not, Your Honor. I think that when you're talking about pro se allegations of ineffective assistance of counsel, I think the trial court has a larger ability to look at ineffective assistance of trial counsel claims, primarily because they're
Well, you give
in
them
the
a
best
liberal
position.
construction, but you don't give them different time limits.
Well, and I in the past, this court's considered these as essentially 60-1507 motions. I mean, under that sort of auspice. So, I think
But
because
that's problematic before sentencing because they don't fit the definition of a person
In custody.
in custody.
right, and I guess I think the problem with holding a defendant to that timing is that the defendant doesn't necessarily have any kind of notice of the short timing for a motion for a new trial.
Well, but they're not precluded from the issue. I mean, they still have the 1507.
They still do, although I would argue that at that point, if the defense attorney and the trial counsel and the court have already basically litigated the issue, here obviously they did not go to the full extent of having an evidentiary hearing, but certainly I've seen many cases where they have gone to the trouble of holding out sentencing for months and months at a time and having full evidentiary hearings on all of the issues and having rulings. And that seems particularly troublesome to say that because a pro se defendant who's filing this pro se, even though he has an attorney, so he's not in that weird area where he's acting as his own counsel as he would if he were, for instance, representing himself at trial. And he's not necessarily expected to know these sorts of deadlines under that sort of odd position. That to then go ahead and say that this is not appropriate to be addressed at this timing, I think is particularly troublesome, because when you do go back in 1507, there's a lot of time that passes. You don't necessarily end up with the same judge, and I think it's important that if this issue is raised before the trial counsel, it's a very practical thing as the district court judge to be able to say, no, I saw what happened in the district court. I saw the way that this case unfolded in front of me, and I have a unique input as to whether or not this is a valid issue, and I think that's important to the extent that we can to protect the defendant's right to raise it at the time when it's most...
Those are all good arguments why it should be, but do we have the authority to make it so if the legislature has set up a jurisdictional hurdle?
Well, Your Honor, I guess I would disagree with the extent of that jurisdictional hurdle. I mean, I think the deadline is to give the defendant or the state the opportunity to have a timely opportunity to respond. So to that extent, I don't know that the legislature fully intended that to be such a hard and fast jurisdictional rule, although I know that this court has previously said so.
On your prosecutorial misconduct issue, were you going to address the evidence in this case as one of the factors that we consider?
Specifically, what did you want?
Well, was this, if it was misconduct, was it harmless error or was it reversible?
Yeah, and we did address that in our brief. I think, as I said, I think the problem with the prosecutorial misconduct issue here is that it is, although there is obviously a lot of evidence as far as that there was a crime committed, I think the degree of that crime and the extent of the client's defense of self-defense to the blow to the head, I mean, they could have potentially believed that he perhaps hit her over the head, but then not believed his statement to the police later that he actually strangled her because of whatever reason, that they could have believed part of his story and not all of it. They could have potentially found a lesser crime, and that a lot of that really does depend on the credibility of the state's witnesses and the credibility of my client's and his statements. And so to the extent that the state has improperly bolstered their witnesses, or to the extent that they've improperly torn down my client's credibility, I think we can't declare that that's harmless under those circumstances.
All right,
Does
thank you.
that address your question?
It's responsive, thank you.
Okay,
Any other questions? Thank you, counsel.
thank you.
Thank you. May it please the court, my name is Ellen Mitchell, Saline County Attorney, appearing on behalf of the state of Kansas today. We wrote long briefs and had to cut and cut to get within our limits and ask for additional and filed supplemental, but the Soto case and the subsequent Hard 50 cases have taken away most of the issues in this case, at least the ones that have been presented through the appellate defender's office. So basically what it boils down to is the ineffective / new trial request and the prosecutorial misconduct. The state contends that the motion was not timely filed and the court does not have jurisdiction to hear this. It is not a particularly, it's not extreme or harsh or unfair to the defendant because he still has the remedy. He can still file a 1507. He'll have 1 year within the date of
What
this
if he
court's
raised
opinion.
ineffective assistance to counsel on his direct appeal and we sent it back for a Van Cleve hearing? I mean, what do we gain?
Right.
I mean, if it's jurisdictional, we shouldn't be able to, if it has to be a 1507, then we, and we're strict about that, then Van Cleve was erroneous.
Correct.
And that's your argument that Van Cleve was wrong?
I guess I hadn't thought about it in that perspective. I just believe that the defendant filed an untimely motion in this case.
Had he labeled it something else, would it be okay?
Yes.
I mean, yeah, you know,
Right.
I often say that you can kind of call a motion whatever you want to call a motion. Most counsel do. We see lots of creative titles of motions. It's just the fact that it was labeled motion for a new trial that raises a jurisdictional bar, right? There's nothing else you're
Correct.
relying on for that argument.
Correct.
Okay.
He,
If he filed a motion to replace attorney for being ineffective, if he claimed a conflict because this attorney was ineffective, we've allowed that. But that wouldn't have gotten him a new trial.
New trial.
Yeah.
and in this case, there was some evidence. I would point out, you know, I think it's in the start of the last volume, the 5th volume, that the defense counsel did note that she put on the record that she had reviewed this case with Dr. Corey May. She referenced it in her voir dire, and she put in there at the end that she had, and that she thought after meeting again with Dr. May, she'd gone over that night and spoke with the defendant in jail and thought better that it was not a wise idea to put her on. So there was some evidence in the record too of why she did not put that expert in, and it's right at the start of the 5th volume as well. As to
Counsel, on that question, do you agree with the defendant that the district court essentially dismissed his motion for new trial arguments on ineffective assistance by determining from the motion files and record that a substantial issue was not presented?
That's correct, and or found that it was trial strategy or the control of trial counsel, how she had proceeded at trial. In the closing argument,
Yeah, let me,
Oh, sorry.
what is, yeah, I want to get to that, that's what I was moving to. You apparently conceded that the use of the word preposterous was improper. And I'm wondering, well, why is that? Why can't a prosecutor summarize a defense as being, that's ridiculous, ladies and gentlemen, let me point to this, this, and this, or it's, why did you concede
because
that?
over the years, I think there was a time when that was acceptable, and the rules on what can be said in prosecutors' closing statements are narrowing and narrowing, and we do a lot of training in that area, and we talk about it a lot. It was in the prosecutor who gave the closing argument. It was in the first part of her closing, and she's describing the defendant's story, and she's saying she's choked, that he claims, and remember, she's 3 times his size. He tells he says that she is choking him at the time, so he's somehow able to reach down and get out of a drawer a cheater bar, which is very heavy, and it was in evidence, and then come around and come from the back and swing that and pop her in the back of the head. The state's evidence was that it was that there were 2 blows to the head.
And then you say, does that make sense? Does this
Correct.
defendant's story make sense in that regard, and that he had to defend himself in that fashion? Preposterous, ladies and gentlemen. And you believe that that's inappropriate?
We talked about it and decided based on what's happened over the last couple of years that that probably would fall in the prosecutor commenting.
It's equivalent to saying,
Her
in
personal-
my opinion, it's
Correct.
preposterous.
Correct.
That's your position?
That is. As to the no motive, this was in response to what the defense had argued about. The defense, this wasn't done until the second part of the prosecution's closing. The defense had stood up and reviewed the witnesses, and she sort of pokes at the IMVU, the Internet Friends, and she said, they kept communicating with her, that the man did. It didn't matter that she was married. They're friends. I don't know. You have common sense. How many of your friends do you sign that message, kiss, kiss to? And he found nothing inappropriate with the relationship that he had with Candy, and perhaps in the IMVU world, that's the kind of relationship people have with other people's spouses. Jennifer Helm was here. The woman from Texas, if you recall, she's never personally met Candy. They talk, they become really close, kind of making fun of her, the relationship in the phone, and she had and said that Ms. Helm had a lot of sensational stories about what Candy had told her, and said, if you're really such a good friend, wouldn't you called 911 when she told you that she had been forced to take an amount of medication or may have overdosed? And so in the response, the prosecutor does say, it's not your job to judge these people. You don't have to like them. You don't have to like their lifestyle, and you don't have, you may not understand or appreciate this internet world. That's not your job. But they came here without a motive. They didn't have any motive to come and testify, and that's the text or the sense that it came in. The state contends that even if that is error, that it's harmless error. It didn't change the outcome of the trial. The evidence was pretty overwhelming in this case with the defendant's confession. The defendant in this stand, maybe it offsets the defendant in this case, stood up during closing argument and called the prosecutor a liar in front of the jury. So I don't think either action or statement caused the jury to have any different verdict than they would have had in this case. Any other questions?
Go ahead.
Jake?
Obviously, this is going back on the hard 50.
Okay.
Or do you have some argument why this should be different than Soto or any of the others?
No, in fact,
Given that it's going back, where I'm leading, given that it's going back, do you have an argument for or against the
Issue five.
us considering the issue of the sufficiency on the aggravating circumstances?
I believe your more recent cases are the appropriate. It was, in all honesty, that was discussed when that came out. Well, why would you look? It would be mute or normally this court doesn't issue opinions unless the issue is directly in front of them. And so I believe the court's most recent cases and position is the correct one, and that you shouldn't, because we could go back. We're going to be in front of a different judge because the judge retired. And that's assuming that we even choose to have a new hearing. But we may present different evidence. We're going to have a different jury. There's going to be different argument. We may have a different defense attorney.
And that's what I was really leading towards for you, is whether from the state standpoint it really does provide any judicial economy if you're going to redo it completely anyway.
It doesn't.
Okay, all right, thank you.
Any further presentation?
No, thank you.
Any more questions? Thank you, counsel. Reserve 4 minutes for rebuttal.
Based on that, unless the court has any further questions, I'll leave the rest of my rebuttal.
I see no questions. Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement.